Supreme Court कहते giving contractual employees same status as regular employees amounts to giving premium to arbitrarily selected process. The court said that if distinction between a regular employee and contractual employee are not made, then the basic concept of hiring through various modes and in different capacities would lose its purpose. कोर्ट कहते जदि डिस्टिंक्शन न हो रेगुलर एवं कंट्राक्चुअल एम्प्लॉय मान मध्य किंतु विभिन्न सोर्स रु आसुंच तेणु सेठी कौन सी पर्पज से वायोलेट हो ना. Supreme Court has observed that if the person who are employed through a contractor and have come to work are given equal benefits and status as a regular employee, it would amount to giving a premium and sanction to a process which is totally arbitrary. एवं से इक्वाल बेनिफिट दि जाऊँगी किंतु कॉन्ट्रैक्चुअल रही बेंच ऑफ जस्टिस आसानुद्दीन अमानुल्लाह Justice Bipul M. Pancholi observed the reason why there are safeguards in regular appointments is that there should not be any favoritism or other extraneous consideration where persons only on merit are recruited through a fully transparent procedure known in law. If the persons who are employed through a contractor and have come to work are given equal benefit and status as a regular employee, it would amount to giving premium and sanction to a process which is totally arbitrary, as there is no mode prescribed in any contract as to how the contractor would employ or choose the persons who are to be sent, except for the basic qualification, that is knowledge in the field for they are required. Contractor under जो मैंने आसुचंती से मैंने ड्यूली फिलअप मीट करूना क्वालिफिकेशन एरिया AOR Y Raja Gopal Rao appeared for the appellant while senior advocate L Narasimha Reddy appeared for the respondent. Factual background रही appeals were filed assailing the order passed by the Telangana and Andhra Pradesh High Court by which the appellant has been directed to grant a minimum time scale of pay to the respondent and also to add annual grade increment as when they fell due from time to time. The appellant had engaged the respondent not directly but through a third party contractor starting from the year 1994. 1994 से contractor के माध्यम से आसीथिले. However, upon the change of contractors, they continued to perform their duties and work for the appellant. They had approached the AP Administrative Tribunal Hyderabad seeking regularization and payment of the minimum of the scale of that post which was given to the regular employee. Tribunal ruled against them and they approached the High Court. The High Court by the impugned order dated has reversed the order of the tribunal. से मैंने क्लेम करथिले जेहेतु से मैंने रेगुलर एम्प्लॉय जहाँ करुछंती से मैंने सेया करुछंती तांको समान दरमा दिया जाऊ किंतु से मैंने ट्रिब्यूनल गला पर ट्रिब्यूनल मना करि दैथिले. हाई कोर्ट ताकू रिवर्स करथिले. Appellant submitted that High Court has failed to consider the basic issue involved in the present case, which is that respondent were never the direct employees of the appellant, inasmuch as there was no such relationship created by the appellant. The only connection which the appellant had with the respondent is that the contractor who had been given contract for providing manpower to the appellant had engaged them, and on that basis they were assigned various works to perform by the appellant. जैसे मैंने contractor under आसीथिले केवल एमानक पई काम करूथिले गवर्नमेंट पई. It was submitted that contract was given with sufficient safeguards regarding the basic rights of an employee, inasmuch as it was stipulated that payment should not be below the minimum wages prescribed by the government from time to time. Deduction contribution would be made by the contractor with regard to such employees. Per contra, the respondent submitted that the stand of the appellant is totally arbitrarily and violates the basic constitutional right of the respondent. It was submitted that besides being discriminatory, it was highly arbitrary, as at the end of the day, the respondent had been directed to be paid only the minimum time scale of the pay attached to the regular post of their respective cadre. तो यह एक सूचाई देउछि जे सेमाने कॉन्ट्रैक्टर अंडर आसीथिले किंतु तांको सेफगार्ड दिया जाइथिला मिनिमम वेजेस देबा पई. बर्तमान से मैंने क्लेम करुछंती रेगुलर पे ऑफ स्केल को employer much less an employer which is the state under Article 12 of the Constitution of India. He said further it was contended that similarly situated person in other municipalities had been given the same benefit and denying the same to the respondents. In the present case itself would not stand the constitutional requirement it is not being discriminatory. Discriminatory how nahi bole କହିଛନ୍ତି. Court observation ଦେଇଥିଲେ. Moot point on which the issue revolved was the nature of the employment relationship of the applicant with the respondent. Court observed, thus at first brush, the reasoning may seem to be attractive, that there was a discrimination as they were also performing the duties as was being performed by other regular employees and were required to be suitably paid, and the minimum time scale of the pay attached to the regular post. However, a deeper probe would reveal that the matter cannot be dealt with in such simplistic way. ସେମାନେ ପ୍ରଥମେ କହିଥିଲେ ଯେ ଡିସ୍କ୍ରିମିନେସନକୁ ଭଲ ଭାବେ ଉତ୍ଥାପନ କରାଯାଇଥିଲା। ସେମାନେ ଯାହା କରୁଛନ୍ତି ରେଗୁଲାର ଏମ୍ପ୍ଲୟ ସେୟା କରୁଛନ୍ତି, କିନ୍ତୁ ଦରମା ଅଲଗା ରହିଛି। କିନ୍ତୁ ସବୁ ତଥ୍ୟକୁ ନଜର ରଖିଲା ପରେ ଜଣାପଡ଼ିଥିଲା ଦ ଟେଷ୍ଟ ହ୍ୱିଚ୍ ୱାଜ୍ ଆପ୍ଲାଏଡ୍ ବାଇ ଦ କୋର୍ଟ ୱାଜ୍ ହ୍ୱେଦର ଦ ରିଲେସନସିପ୍ ହ୍ୱିଚ୍ ଇଜ୍ ଡାଇରେକ୍ଟ ବିଟୱିନ୍ ଟୁ ପାର୍ଟିଜ୍ in whatever manner can be differentiated from a relationship which had no direct connection with the two parties who are contesting, but rather than the relationship is through a third party, which the present case is the contractor. तो एथिरे कोर्ट कहिथिले जे जो मोड रे पोस्टिंग हेछि ताहा मध्ये इलीगल अछि and illegality in the terms of the condition of the contract so as to make it ultra vires any constitutional provision or to make it discriminatory. Another issue which was dealt by the court was that respondent being the position and the relief given being the minimum of the time scale of the pay attached to the regular post cannot be termed as giving them something which was not due or something excessive, for ultimately they also have a family to support. जो कथा कुआ जाइथिला मिनिमम पे स्केल दवा पाई सेटा गोटे बड़ कथा नुह, सेटा दया नुह, आम अधिक किसी दे दौरान बोली भाविबा नहीं। तेणु it was also observed that when the employees workmen are taken through a contractor, it is the absolute discretion of the contractor as to whom and through which mode he would choose such person to be sent to the principal. Court concluded, having passed the order, we feel that sometimes justice is required to be tempered with mercy as human factors cannot be totally lost sight of. In such view of the matter, we would require the appellant to look into the whether the jobs which were being done by the respondents in the background that they have not been disengaged are returned to the contractor on the ground of being unsatisfactory, having uninterrupted services under the appellant for decades can be regularized on post, which prima facie appears to be perpetual in nature. तो सब बड़ कथा रही कोर्ट कही जिते कंट्राक्टर अंडर से रेगुलराइजेशन करहब किसी ग्राउंड रे। तो निश्चित भाव गोटे बड़ खबर रही देखा परवर्ती अपडेट। डायरेक्टरेट ऑफ एलिमेंटरी एजुकेशन ओडिशा भुवनेश्वर तरफ 738 नंबर चिठी 12/1/26 टू ऑल डिओंग रही चिठी ऑल डिस्ट्रिक्ट एजुकेशन ऑफिसर ऑफ द स्टेट। सब्जेक्ट रही सबमिशन करने डाटा रिगार्डिंग इन सर्विस टीचर्स लाइकली टू बी अफेक्टेड जो मैंने अफेक्टेड होगा जाऊँच 1/9/25 एवं 17/11/25 रूलिंग अनुसार रिगार्डिंग क्वालिफिकेशन ऑफ टीचर एलिजिबिलिटी टेस्ट मेमो नंबर मेंशन होती 831/SME 8/1/2026 एडिशनल सेक्रेटरी टू गवर्नमेंट मेमो करते डायरेक्टर को सर मैडम इन एनक्लोजिंग हियर विथ द लेटर नंबर डेटेड 31/25 लेटर टी जो पठे 31/25 और जॉइंट सेक्रेटरी इंस्टीट्यूशन एंड ट्रेनिंग देखो रही मिनिस्ट्री ऑफ एजुकेशन डिपार्टमेंट ऑफ स्कूल एजुकेशन एंड लिटरेसी गवर्नमेंट ऑफ इंडिया जो एडिशनल सेक्रेटरी चिठी करते आई एम टू रिक्वेस्ट यू टू सबमिट द रिक्वायर्ड इनफॉरमेशन डाटा इन द प्रेस्क्राइब्ड फॉर्मेट इन एक्सेल स्प्रेडशीट बाय 13/1/26 अर्थात आसंता काले सुधा देवाई कहुई ये रिगार्डिंग आगर मध्य आम वीडियो देखी एवं सबुठार बड़ कथा 31 डिसेम्बर 2025 रे पठेइछंती भारत सरकार ये मेंशन करिछंती 24/3/25 जोटा होता चिट्ठी अपडेट करने रिक्रुटमेंट रूल कन्फर्मिटी आने with minimum standard prescribed by NCTE in the light of judgment of Honorable Supreme Court. I would be grateful. से चिठी रे कौन थिला ना एथिरे मुख्यतः थिला केंद्रीय विद्यालय रिक्रुटमेंट रूल को पाथ्य करी स्टेट माने अपडेट करिवे से मानकर अप्रोप्रिएट रिक्रुटमेंट रूल। तो निश्चित भाव ये गोटे बड़ खबर थिला समस्त जहाँ को वर्तमान यही फर्माट देवाई कहुई। तो निश्चित भाव ये आशा करा कैडर स्ट्रक्चर निश्चित भाव ए डायरेक्टर एलिमेंटरी गोटे संकेत मिलगला। ये देखिए देखो ये चिठीटी को जो डायरेक्टर साइन मारी केंद्रीय विद्यालय ढांचार रिक्रुटमेंट रूल है समस्त जिला शिक्षाधिकारी चिठी लिखिले। देखा परवर्ती।